Just nickname a road.
Senate, please come to order. For those who are observing on the screen, we apologize. We had technical malfunctions and had no sound, which you may have known. We've now hopefully got it back up and online. When we recognized we had lost sound, I just ordered first reading of H 829 by title.
H 829, an act relating to long-term housing solutions.
Now you've heard the first reading of the bills referred to Committee on Economic Development, Housing and General Affairs. We now have for reference H 871. H 871 passed the House on April 2nd. Please listen to the first reading of the bill by title.
H 871, an act relating to the development of an updated state aid to school construction program.
Now you've heard the first reading of the bills referred to Committee on Education. We now have H 875 for reference. It passed the House on, looks like probably, April 2nd. Please listen to the first reading of the bill by title.
H 875, an act relating to the State Ethics Commission and the State Code of Ethics.
Now you've heard the first reading of the bills referred to Committee on Government Operations, and we have H 879, which passed the House on April 2nd. Please listen to the first reading of the bill by title.
H 879, an act relating to the Emergency Temporary Shelter Program.
Now you've heard the first reading of the bills referred to Committee on Health and Welfare. That brings us to the orders of the day. The order of the day that we have is H 543. H 543 is read for the first time and referred to the Committee on Health and Welfare, which considered the same and recommends that the bill ought to pass. The bill is then referred to the Committee on Finance, which also recommends that the bill ought to pass. Please listen to the second reading of the bill.
H 543, an act relating to Vermont's adoption of the Social Work Licensure Compact.
Now you've heard the second reading of the bill. For the report of the Committee on Health and Welfare, the Senator from Rutland.
Thank you, Mr. President. I'm here today to report H 543, which can be found on page 1938 of the calendar. It's entitled An Act Relating to Vermont's Adoption of the Social Work Licensure Compact. The bill passed by your Senate Health and Welfare Committee favorably 5-0. It's a long bill, so I'm going to go section by section with this. Section 1 is it creates a new 26 VSA Chapter 61, Subchapter 2. Section 3214 is the Vermont adoption of the Social Work Licensure Compact. The format, and text of the compact has been formed to the conventions of the Vermont statutes annotated, and it is the intent of the General Assembly that this subchapter be interpreted as substantively the same as the Social Work Licensure Compact that is enacted by other compact party states. The purpose: the compact preserves the regulatory authority of the states to protect public health and safety through the current system of state licensure. Subsection 3215, purpose. That lists the multiple compact purposes, including facilitate interstate practice of regulatory social workers by improving public access of social work services, reduce duplicative requirements associated with holding multiple licenses, promote mobility and address workforce shortages, and to allow the use of telehealth to facilitate increased access to regulated social work services. Subsection 3216 is definitions. There are actually 5 pages, and from page 3 to 7, if anybody wants to go through the book. State participation in the compact. To be eligible for the compact participation, potential member state must license and regulate social work as either clinical, master's, or baccalaureate, bachelor's categories. Require applicants for licensure to graduate from a program meeting certain criteria. Require applicants for clerical licenses to complete a period of supervised practice and have a mechanism for receiving, investigating, adjudicating compliance about complaints about the licenses. To maintain compact membership, a member state must require applicants for a multi-state license to pass a qualified national exam for the corresponding category of multi-state license sought. Participate in the commission's data system. Notify the commissioner of any adverse action or availability of current significant investigative information regarding a license. Implement procedures for considering criminal history reports, records of multi-state license applicants. Comply with commission tests. Require an applicant to obtain or retain a license in lower home state and meet the home state's qualifications for licensure or renewal of licensee. Authorize a licensee holding a multi-state license in any member state to practice in accordance with compact and commission terms, and designate a delegate to participate in the commission meetings. A member state must designate the categories of social work license that are eligible for issuance of a multi-state license. Home state may charge a fee for granting the multi-state license. Section 3218, social worker participation in the compact. To be eligible for the multi-state license, an applicant, regardless of category, must hold or be eligible for an active, unencumbered home state license. Pay applicable fee, including a state fee, submit fingerprints or other biometric data. Notify home state of any adverse action, encumbrance, or restriction of professional license taken by any member or non-member state within 30 days of the action. Meet continuing competence requirements established by the home state. Abide by the laws, regulations where client is located at the time care is rendered. An applicant for a clerical category multi-state license must fulfill one of the following competency requirements. Passage of a clinical category qualifying national exam. Applicant licensure in applicant's home state at the clinical category. Beginning prior to national exam requirements for the home state, or substantial equivalency of the foregoing competency requirements that the commission determines by rule. Attain at least a master's degree in social work and fulfill a practice requirement, 3,000 hours, 2 years of clinical supervised practice or substantial equivalency. An applicant for a master's category multi-state license must fulfill one of the following competency requirements: passage of the master's competency qualified national exam, applicant licensure in applicant's home state, beginning prior to national exam requirements by the home state, or substantial equivalency of the foregoing competency requirements for the commission determined by rule, and attain at least a master's degree in social work. Multi-state licensure for a regulated social worker is subject to the renewal requirements of the home state. A regulated social worker services in a regulated social worker services in a remote state are subject to the member state's regulatory authority, including, in accordance with due process, removing the social worker's multi-state authorization to practice in the remote state for a specific time, the imposition of fines, or any other necessary sections. If a multi-state license authorization to practice is encumbered, the social worker's multi-state license authorization to practice shall be deactivated in all remote states until there is no longer an encumbrance. Section 3219. Issuance of a multi-state license. Upon receipt of the multi-state license application, the home state licensing authority shall determine applicant's eligibility for the multi-state license. If eligible, the home state shall issue a multi-state license authorizing applicant or regulated social worker to practice in all member states under multi-state authorization to practice. Upon licensure, home state shall designate whether regulated social worker holds multi-state license in bachelor's, master's, or clinical category of social work. The multi-state license issued by the resident's home state shall be recognized by all compact member states under a multi-state authorization to practice corresponding to each category of licensure regulated in each member state. Section 3220, Authority of Interstate Compact Commission and Member State Licensing Authority. Compact does not reduce the member state ability to enact and enforce laws, rules related to practice of social work in the state where the laws, rules are not inconsistent with the compact. The compact does not impact issuance or discipline of single state license. The compact does not reduce ability of a remote state to take adverse action against a licensee's multi-state authorization to practice in that state. Compact does not reduce ability of a licensee's home state to take adverse action against a licensee's multi-state license based on information provided by a remote state. Section 3221. Reissuance of a multi-state license by a new home state. Licensees can hold multi-state license in only one member state at a given time. Describe processes for licensees to change home state when licensee moves. And the compact does not impact the licensee's ability to hold multiple single state licenses at once. Section 3222, military families. It enables family, military member or spouse to retain home state designation while the member is on active duty. Adverse action, section 3223. The remote state has authority to take adverse action against regulated social workers' multi-state authorization to practice only within that member state. Only a home state may take action on the individual's multi-state license. If adverse action is taken, the licensee's authorization to practice in all member states is deactivated until encumbrances are removed. The home state shall give same priority and effect to conduct conduct reported from another member state. A member state may take adverse action based on factual findings of another member state, so long as the member state follows its own procedures. Member states may conduct joint investigations, and the compact does not authorize member state to impose discipline against regulated social worker holding a multi-state authorization to practice for lawful actions within another member state. Section 3224, establishment of social work license compact commission. A compact member states established commission which shall come into existence after effective date of the compact. Each member state shall have one delegate to the commission. The commission shall meet at least once annually, and the commission and powers are to establish fiscal year of the commission, establish the code of conduct and conflict policies, establish and amend rules and bylaws, maintain financial records, initiate and conclude legal proceedings, maintain and certify records provided to the member states, purchase and maintain insurance bonds, borrow, accept, or contract for services, personnel, conduct annual financial review, hire employees, elect or appoint officers, etc., assess and collect fees, accept appropriate gifts, donations, grants of money, etc., lease purchases, retain, own, hold, etc., property, sell, convey, mortgage, etc., property, establish a budget and make expenditures, borrow money, appoint committees, provide and receive information from law enforcement, establish executive committee, and determine if the state's adopted language is materially different from the model compact language. Outline duties of executive committee and describe processes for commission meetings. Data systems, section 3225. The commission shall provide for the development, maintenance, operation, and utilization of a coordinated data system. Requires a member state to submit a written data set to the data system of all individuals to whom the compact is applicable, including identifying information, licensure data, adverse action, non-confidential information related to alternative program participation, any denial of application licensure, presence of current significant investigative information, etc. Member state contributing information to the data system may designate information that may not be shared with the public without express permission. They can expunge data in accordance with federal law or while the state contributing the information shall be removed from the database. 3226 rulemaking. Commission shall promulgate rules for the implementation and administration of the compact. A rule has no effect where the majority of member state legislatures reject the rule or a portion of the rule within 4 years of its adoption. Describe rule and to describe rulemaking process. 3227 oversight, dispute resolutions and enforcement. The executive judicial branches of member state enforcement and compact, judicial proceedings by or against commission are brought in jurisdiction that commission is located. The commission provides notification of default to member state that has defaulted in its obligations under the compact. It provides process for state termination from the compact, dispute resolution, and legal enforcement. Section 3288, effective date, withdrawal, and amendment. The compact takes effect on the date on which the compact statute is established by a 7th member state. A member state may withdraw from the compact by repealing and enacting statute. Compact does not invalidate or prevent a licensure agreement or cooperative agreement between a member and non-member state that does not otherwise conflict with the compact. Section 3229, construction and service severability. Compact liberally construed and provisions are severable. 3230. Consistent effect and conflict with other state and conflict with other state laws. A licensee providing services in a remote state under a multi-state authorization to practice shall adhere to the laws and regulations of the remote state where the client is located in the time of care, at the time of care. Section 2, amendment duties of Office of Professional Regulation, 3 VSA, Section 123. Authorizes OPR to inquire into the criminal background histories of social workers licensed under 26 VSA, Chapter 6. And the effective date is effective upon passage. Your Committee on Health and Welfare heard from Representative Brian Cena, sponsor from Burlington, Nolan Langwell, senior analyst, fiscal analyst, JFO, Lauren Lehman, the General Counsel, Office of Professional Regulation, Secretary of State's Office, Katie McLean, Legislative Counsel, Angela Paoli, Mental Health Provider, President, National Association of Social Workers, and the House Committee on Appropriations, Nolan Langwell and Katie McLean. Thank you, Mr. President.
Bill is then referred to Committee on Finance, which reviewed the bill and recommends that when the bill, that the bill ought to be read a third time. For the report of the Committee on Finance, Senator from Windsor.
Thank you, Mr. President. The Finance Committee did take testimony on this bill, and we have the loss of revenue to the state would be that at present, out-of-state practitioners wishing to practice in Vermont have to buy a Vermont license. And now coming in under the compact, the state would not get that revenue. We have concluded that in the context of the benefit to the state of membership in the compact, and also just on the numbers, that the effect on the fisc will be de minimis, and we voted unanimously to recommend that the bill should pass.
So the question is, shall the bill be read a third time? Senator from Caledonia.
Thank you, Mr. President. Would it be appropriate at this time to offer an amendment?
It sure would.
All right, I would have it distributed, please. Thank you, Mr. President. Now the amendment has been distributed. I'll explain it. As you can see, it's being offered by myself as well as Senator Lyons. We discovered after the passage of our Budget Adjustment Act that something that had been included and offered as part of our negotiation process in the Committee of Conference on the budget adjustment turned out to be an error. We, in this body, had continued the emergency housing benefit for vulnerable individuals through the end of the fiscal year with no time limit. The other body came back with recommended language in reference to a form because one of the things that we realized that an individual might not have the permanent total disability test that is required by Social Security or SSI, but could be recently released from the hospital, could have some kind of a temporary health condition, and there needed to be some verification as to that individual's health status to determine eligibility under the vulnerable category. In the language that we accepted, reference was made to a form. It was a form that was developed during COVID, and it no longer exists. Obviously, this was brought forward as something that needed to be corrected in terms of legislative intent, because our intent was certainly not to have a self-declaration form that no longer was in effect. So what this amendment does is to provide clarity around the intent, correct and eliminate the reference to a form, an obsolete form, and just indicate that it would be a form developed by the department that would include the information that's here on the amendment. I would say that we've looked at who is in that category. And I want to assure people it's not, you have to have a physician statement. It could be a mental health clinician. It could be a variety of healthcare providers that would provide the completion of the statement. It would have to be someone who is certified and and can provide their credentials, their credential number, address, and phone number. So it's sort of a standard practice to document eligibility, and so we regret, I guess, we should not have assumed anything about the reference to the form, but we did. And so the purpose of this amendment is to rectify the situation that was created by the language that was used. And so it's for that reason I'm offering this amendment to this bill. Obviously, it's time sensitive. This is a bill where there's not a difference between the other body and the bill as we're passing it out, and it would be effective upon passage. So getting some clarification is quite time sensitive. And we ask this body's consideration of this amendment to address this unfortunate situation that got created by reference to a non-existent form. Thank you.
So the question is, shall the senator from Addison,
May I inquire of the presenter of the amendment?
the senator from Caledonia is interrogated as the proposer of the amendment?
Thank you, Mr. President. I just want to clarify, thank you for the amendment. I think I understand it, but is this in order for people who have a health condition or a disability to be able to maintain their housing as part of the emergency housing
Yes, it would.
program?
And anyone knew, that's correct. It's to confirm that they meet one of the eligibility conditions under the vulnerable category. And this would be the mechanism to establish their eligibility as a qualifying vulnerable household.
Okay, so it's less restrictive than requiring a federal definition of a disability.
Absolutely.
Okay.
The test for both SSI, supplemental security income, or the Social Security disability really requires that you have a permanent total disability. And we recognize that people could have a temporary health condition very legitimately, should qualify as a vulnerable. So yes, it is a less restrictive test than
Okay.
being permanently and totally disabled.
Great. Thank you for that. I thank the presenter, especially on a day like today, where there's literally snow falling. We want to make sure that people can maintain their housing and not make it more difficult for them. So thank you very much.
Thank you.
Question is, shall the bill be amended as offered by the senator from Caledonia and the senator from Chittenden Southeast? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it. You have amended the bill as offered by the senators from Caledonia and Chittenden Southeast. The question now is, shall the bill be read a third time? Are you ready for the question? Senator from Orleans.
Thank you, Mr. President. Many years ago, we did what we called the Northeast Dairy Compact. And we put that together here in Vermont, sold it all over New England to the other states. And it ended up bringing our farmers $50 million in revenue, additional revenue. And it worked really fine. A few years ago, we passed a compact allowing nurses to be licensed from other states along with our state. And I'm just a small dot in the world of healthcare, but I do serve as, or did serve as chair of our local VNA, and I'm on the board of directors of a VNA in Orleans and Essex counties. And so far, it costs us that compact, the nurses compact, has cost us over $1 million a year in outgo and has not served us very well. Now we have, and we had to, of course, raise our rates, and as we all know, as we watch our budgets, the budgets for healthcare keep going up, and golly, we wonder why. Well, in my mind, we helped cause that by allowing that. And now we're doing a compact to allow our healthcare workers to join a compact. And my question is, how many millions more is that gonna cost us? And how many people from one end of our state joins the compact and drives 50 miles south to the mid part of our state and doubles their pay? And, you know, it's all fine and good to do all these, I guess, great things, but did we get an impact study of what this could cost our Vermont healthcare system by allowing this system to be put into place? So I guess my question should be directed to the chair of the Health and Welfare Committee.
So are you requesting to interrogate the chair of the Committee on Health and Welfare?
Yes.
The senator from Chittenden Southeast is interrogated as the chair if they so choose.
So, Madam Chair, could you